Thank you, Mr. Chairman. Judge Kavanaugh, welcome. Thank you for your service to this country, and thank you for the willingness you have expressed to take this additional assignment. And thank you to your family. We welcome them as well. The process on which we're about to embark is one of maybe not the most important duties entrusted to the Senate: advice and consent on judicial nominations. Ultimately, a fair and proper judge, Supreme Court or otherwise, must follow the law and not make laws from the bench. Upon receiving his nomination to serve as an Associate Justice of the Supreme Court, Judge Kavanaugh stated, "My judicial philosophy is straightforward. A judge must interpret statutes as written, and a judge must interpret the Constitution as written, informed by history and tradition and precedent." Isn't that the ideal of a judge steadfastly committed to the law? No one seriously questions Judge Kavanaugh's qualifications to serve as an Associate Justice on our nation's highest court. He is vastly experienced and widely respected for his intellect, his honesty, and his legal acumen. With over 300 authored opinions and 12 years of service on the bench, he is a judge with a clear record, demonstrating that he applies the law as written and enforces the Constitution. He values precedent and has written, along with Justice Gorsuch and others, The Law of Judicial Precedent, a scholarly piece on the importance of stare decisis. Sadly, much of the discourse surrounding Judge Kavanaugh's nomination deals not with the content of his legal opinions, his judicial philosophy, or temperament, but rather, as today's discussion has shown, the spurious notion that our distinguished chairman has not been rigorous or fair or transparent in navigating the requisite document production efforts required by this committee. Those claims are wholly without foundation. There have been 57 days since the announcement of Judge Kavanaugh's nomination on July 9 and today's confirmation hearing. This is a longer period of time than senators had for Justices Sotomayor, Kagan, and Gorsuch. Justice Kavanaugh also submitted over 17,000 pages with his bipartisan Judiciary Committee questionnaire, the most extensive questionnaire ever returned by a nominee to the Supreme Court. The committee also received more than 440,000 pages of documents related to his service in the executive branch. This, too, is more than any Supreme Court nominee to date. As has been said earlier, in fact, it's more than the last 5 nominees combined. I applaud Chairman Grassley and his dedicated staff for their tireless work in reviewing these documents and making the vast majority publicly available as quickly as possible. And frankly, Mr. Chairman, I believe the American people appreciate your efforts, your transparency, and your commitment to a fair process. Now, I want to make one side note. It was said here today that the number of documents provided by now Justice Kagan, who was also a nominee who had served in the White House and had many, many documents relating to her service, that 99% of the documents requested for her were provided. One problem with that fact, and that is that when Justice Kagan was before us, she had been the Solicitor General. There were probably more pages relevant to her service there than to your service. We don't know the number, because the Republicans agreed, after a strong disagreement with the Democrats, that we wouldn't request those documents because the White House claimed they were sensitive. The Democrats have not made that agreement with the Republicans this time. But it's notable, I think it's incredibly important to note, that this argument that is going on today about the balance of document production is simply a trumped-up argument. These facts aside, many of my colleagues continue to criticize this process. Their motives are clear: use any means available to attempt to delay the confirmation process of a well-qualified jurist fit for the job indefinitely. I strongly agree with the comments of many of my colleagues here today. Senator Cruz pointed out what was really at stake. Senator Sass pointed out why it is that Congress needs to be the part of our federal government that makes the law, not the judiciary. Senator Kennedy has followed up on that thought, as have many of my other colleagues here today. I think one point that Senator Cruz made deserves repeating. Much of what we are hearing today, and we'll hear for the remainder of this process, is ultimately an effort to relitigate the last presidential election. In fact, we have just heard Judge Kavanaugh attacked and stated to be unqualified because he is a Trump nominee. Other Trump nominees have also been attacked here today. The attack is on President Trump, not on their nominees, because of an unwillingness to accept the outcome of the last presidential election. Judge Kavanaugh, as the nominee, has been widely recognized for his judicial temperament and his detailed legal writings in defense of the Constitution. His opinions are widely cited by his fellow appellate judges and even the Supreme Court. And although his integrity was just challenged, stating that no matter what he says to this committee, he will vote the other way once put into office, put into the Supreme Court. The fact is that his record as the chairman has already outlined disproves that. He serves on the D.C. Circuit Court of Appeals, a court on which more of the judges who serve have been appointed by Democrat presidents than Republican presidents. Yet he has voted 97% of the time with his colleagues in the majority on that court, showing that he will follow the law and that he does so with the majority support of broad and, I was going to say bipartisan, but nonpartisan judges who are appointed by Republican and Democrat presidents and who consider some of the most important cases in America today. That is the judge we have before us. He's a judge's judge. Many critics argue that Justice Kavanaugh would play an instrumental role in reversing a number of Supreme Court precedents. However, I wonder how one can draw that conclusion given his record of exhaustive and weighty consideration of important legal questions on a court such as the D.C. Circuit. I recognize that it is politics driving these attacks, and so do the American people. They know what's at stake here. Moreover, in his legal opinions, Judge Kavanaugh has consistently demonstrated a willingness to rein in both Congress and the executive branch when they overstep their respective constitutional grounds. Judge Kavanaugh understands and is focused on the principle that a judge is a servant of the law, not the maker of it. We should take him at his own words. The judge's job is to interpret the law, not to make the law or policy. So read the words of the statute as written. Read the text of the Constitution as written, mindful of history and tradition. Don't make up new constitutional rights that are not in the text of the Constitution. Don't shy away from enforcing constitutional rights that are in the text of the Constitution. Those are Judge Kavanaugh's words. That is the man who sits before us, nominated to be a justice on the highest court of our land. Judge Kavanaugh has the backing of his former law clerks and law students, his colleagues on the bench appointed by both Republican and Democrat presidents, and many members of his local community in which he remains so closely involved. He is a man of honor, integrity, and well-respected in the legal community. There is no dispute he is qualified to serve on our nation's highest court. Mr. Chairman, I look forward to the hearing from the nominee himself when we all get done with our statements. The next few days will prove insightful as we discuss with Judge Kavanaugh for the public to hear, in his own words, the proper role of a judge in our constitutional system. I look forward to this hearing. And again, Judge Kavanaugh, thank you for being willing to be here. Thank you, Mr. Chairman.